Yes, hi everyone. In this video, I'm going to talk about resulting constructive trust. There's a lot to be said, a lot to be analyzed. The law has evolved um, for the past in the past couple of years, and a more broad brush approach is taken by the court, um, using um, using the constructive and resulting trust as more of a guise in order um, to seek the intention of the parties with regards to their beneficial shares and the extent of the beneficial shares in the property. So let's say that two parties have purchased a house, and they have purchased the house as a joint venture. Now, let's say that they purchased the house as a joint venture, and they both join legal mortgagors, and they have paid that house out of the funds of the mortgage. Now, would there be a resulting trust in their favor? Would a resulting trust presumption um, rebut the presumption of uh, joint beneficial ownership by virtue of their joint legal ownership that they're holding in equal shares? In that case scenario, um, let's say that in that case scenario, they're both legal owners. So we're starting from the point that equity follows the law. So they hold in equal shares. And since they are both joint legal mortgagors, then the case of Curley versus Parks is going to apply, which simply states that um, they, since they are liable jointly for the mortgage, they are liable under the mortgage, then they are taken to have contributed towards the purchase price of the house. So since it is a joint venture, um, it could have been said that the joint legal ownership presumption has been rebutted in favor of resulting trust. What would that resulting trust be? It would have been um, the proportion of each of the joint tenants to the extent of their contribution towards the purchase price, which is actually the 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 liability under the mortgage. So in either case, though, the result is going to be the same. They're going to be holding in equity in equal shares, and that's what I want you to understand. Now, let's say that one of the owners has, in the same scenario, same house has been bought as a joint venture, and one of the owners has contributed solely towards the mortgage um, installments of the house, and the other hasn't. So it is a joint mortgage. So what is the situation going to be in that case scenario? Well, there is still the case of Curley versus Parks, which says that when uh, a liability under mortgage is assumed, that is taken to be the um, that is taken to be as a contribution towards the purchase price. However, let's say that um, one of the owners has been making contributions towards the mortgage installments, and now he wants to claim a bigger share by virtue of a resulting trust. Um, After having made those mortgage contributions, would that be possible under a resulting trust? Well, I have to say that a resulting trust is a very limited extent um, instrument of equity that allocates rights. And in that scenario, the house has already bought up, and we do not have to neglect that fact. It has, the equity has already been used up, and it has been bought through the funds of the mortgage loan, for which both um, joint legal owners are liable. They're both joint mortgagors, and they are taken to have already paid in equal shares, in equal contributions, on a 50-50% basis, through by being joint mortgagors. So it's already been purchased. Now, if the other mortgagor makes payments towards the purchase price, that would go against the Curley versus Parks decision, or Carley versus Green. Also, Holdsworth's Laws of England, 5th edition, states that mortgage repayments cannot be held to be uh, mortgage, contributions towards the purchase price of the house, although they could give rise to an inference of a constructive trust. So no resulting trust there. However, the possibility of a constructive trust could be explored further. Now, it leaves a door open for a constructive trust. A constructive trust could arise through common intention, that is like an express agreement that they were going to share the house together. Now, you got it there, it's a joint venture, and it could also arise through inferences such as I said previously, um, by way of mortgage contributions towards the purchase price, and as easily it can arise, as easily can be rebutted. Say it's the case of Lightfoot versus Lightfoot. There's like positive evidence that shows that mortgage installments were basically made in the absence of knowledge of the party who had who was awarded by court the sole beneficial ownership, or who was gonna receive the entire beneficial ownership under a family order. Yeah. So, and could also the common intention could also arise in a family setting, or it could also rise a common intention could also arise in circumstances where um, you know the other party, let's say, see for example Fowler versus Bowron, makes it possible through um, certain acts, certain conduct, makes it possible for the legal owner to keep paying the mortgage installments. That's like by taking care of the kids, paying up the bills, paying up the insurances, etc., etc. It makes it easier for him. So the common intention could be inferred through that through that conduct, that that through those dealings, as was actually mentioned in Hawksley versus Hiscock. But still, um, could there be a constructive trust? And the if the payments of the mortgage, which were made in reliance, let's say, of an express agreement, or could be inferred, then there would be the necessary detrimental reliance as well for constructive trust. But would that be possible? Um, in that case, it could be argued that it depends what contributions to the purchase price is. If the joint venture agreement does not make any provisions with as regards to the definition of contributions, then it could be argued that contributions have already been made. And since they have already been made, the party was just making contributions based on um, an agreement that didn't provide for this um, this contributions like mortgage installments. So it was not in pursuance of this very agreement. Now, it could be inferred. Now, again, I can't see any circumstances out of the facts that I just described that would allow the inference of common intention through those mortgage contributions. Something else would need to be there. Something else would need to be present, in my opinion. And with regards to like behavior and conduct, um, we haven't, again, there's no circumstances that say, um, that indicate that the, you know, the payment of the mortgage installments wasn't somehow, there was some kind of a variation, let's say, of that agreement, so that Stack versus Dowden could apply, or even Alaska versus Alaska, which was a resultant trust case. However, the most appropriate academically category would have been constructed trust. Um, for example, let's say that there could be variation, alteration of the of the the shares, so the extent of the equal shares uh, of each party under the joint legal mortgage. And then again, Curley versus Parks explicitly states that mortgage contributions, cannot alter, cannot vary the shares that two parties already hold after they have purchased a house. So where does that leave us? Let's assume that the joint venture agreement provided that each party was going to, each party's shares, each party's extent beneficial ownership was going to mirror, was going to reflect, was going to be equal to the contribution that they made towards the house. Now, in that sense, the house has already been purchased. I can't see why, in a commercial setting, the payment of contributions, the payment of mortgage installments would vary, would alter the shares that they already hold. On the other hand, though, on the flip side, a constructed trust could arise if, for example, the mortgage payments were made with the knowledge of the other party. There's no positive evidence that those mortgage payments were a loan, and it actually could be shown that um, there was a change, an alteration of of the agreement, of the common intention of the parties, that mortgage contributions um, would reflect a change in the ownership that they were already holding in equal shares by virtue of their joint legal mortgage liability. The party who is still liable under the mortgage, his liability has been extinguished since the other party just paid the mortgage installments, and he's no longer liable. Therefore, he's not hasn't contributed anything to that property as time went by. But I could also only see like a variation agreement working in that way, and it has to be supported by the circumstances, because the case of Curley versus Parks stands the test of time and is there. Now, something needs to be shown beyond the mortgage contributions to vary, to alter the existing shares of the parties. Some form of, detrimental reliance on, in the entire context of the joint venture, joint enterprise, to show that in reality the other party's mortgage installment contributions um, would eliminate um, any equity left in the other party's um, share, where that was really not meant to be the case. That's why they were like joint mortgagors. He has been taking extensive liability for that, and there is until the house was paid off, the mortgage was paid off. He has been liable, and there is nothing on the table, such as the case of Cartland versus Goodman, which would rebut a presumption of a resulting trust to to the to the extent of half the extent of the house being held by the other party, who were jointly liable. There isn't something such as that he was never going to be responsible under the mortgage. However, if he could make mortgage contributions, he chose not to. Then again, you can see that it was, it could be argued that um, he just, just like in Jones versus Kernet under constructive trust, that could be inferred from that conduct that he gave up on the joint venture since the payments were made in his knowledge. And also, if we see the case of Geary versus Rankin, 2012, Court of Appeal, that was an acquisition case, and it was ruled that no liability held by one of the parties in relation to the business meant that there was no common intention to share the property. And in contrast with a joint acquisition, where the other party already has a share in the property by virtue of his mortgage liability. Therefore, it would be hard to resist an alteration of quantum of joint ownership based on an outstanding mortgage liability, as opposed to using it to acquire a share in the property through an inference of a common intention. What I wanted to say with that last line is that that case was an acquisition case, and it was ruled that there was no the fact that no liability was held by the person who wanted to acquire a share in the other party's business. It actually meant that there was no intention, was no common intention to share the property equally, regardless of the fact that she had done series of stuff that helped the other person grow and maintain that business. However, in a joint acquisition, whereas like the parties, such as the one that I'm describing, are joint legal owners, the fact that there is already a mortgage liability or the fact that there is already mortgage liability is that mortgage liability means that there is something needs to be shown to means that there's an intention for them to hold in equal shares, since they holding it they're both joint legal mortgagors. So something more needs to be shown. There might be a small um, small hope with the whole variation of shares. And in conclusion, a resulting trust could also be proved by the fact that by the fact that both parties are, um, by the fact that there's a joint venture there, and both parties intend to um, put and then turn to get whatever they have put in there. So thanks again for watching, and I will see you in my next video. Subscribe to my channel for more videos like that.